The Honorable Court of Criminal Appeals of Tennessee is now in session.
Good afternoon. This is the March session of the Court of Criminal Appeals in Nashville. The panel this afternoon is Judge Kelly Thomas from Maryville, Judge Rob Montgomery from Kingsport. I'm Norma McGee-Ogle from Sevierville. Each side will have 20 minutes for your arguments. If you would like to save any of that time for rebuttal, please let me know before you begin your arguments. Mr. Taylor, you may begin.
I believe this is a state appeal.
State appeal, I'm sorry.
That's okay.
Thank you.
But may it please the court, Courtney Orr, on behalf of the state, I would respectfully request 3 minutes for rebuttal.
I will note that.
First, this petition for post-conviction relief should have been dismissed as untimely filed. I would like to address first the issue raised in the petitioner's brief regarding waiver. The state has not raised this jurisdictional statute of limitations claim. In both the statute setting forth the post-conviction limitations period and the Tennessee Supreme Court and State v. Nix have stated that timely filing of the petition is an element of the right to seek post-conviction relief, and it is incumbent upon the petitioner to either allege facts that show timeliness or facts that would excuse untimely filing and suggest due process tolling. This is a jurisdictional requirement, and the state is not required to raise it as an affirmative defense in the post-conviction court. Indeed, this court in Ruby Ruiz versus State said, if we conclude that the post-conviction court did not have jurisdiction to consider the petition for post-conviction relief, it must be, the petition must be treated as untimely, even if the post-conviction court considered it as timely, the parties considered it as timely, and timeliness was not addressed below. Simply put, it is incumbent upon the petitioner to allege facts within her petition to show timely filing or due process tolling, and here she failed to do that. She acknowledged in her petition that the petition was given to the prison mailing authorities on September 18th, 2018, which was more than 1 year after this court released its opinion in the direct appeal. The petitioner did not seek Rule 11 review after her direct appeal, so this date of this court's opinion on the direct appeal is controlling for the statute of limitations purposes. The petitioner acknowledged that it was untimely filed, and the only explanation she gave for her untimely filing in the petition is that it was filed within 1 year of when a Rule 11 application would have been due. As this court explained in Womack, that 60-day period does not toll a statute of limitations for post-conviction purposes if no Rule 11 application was filed. Here, no Rule 11 application was filed in the Tennessee Supreme Court, so therefore, the post-conviction petition should have been filed on or before September 1st, 2018, and the petitioner failed to do that. And because she failed to allege facts within her petition to excuse untimely filing, she has not satisfied the requirement to show that due process would toll the statute of limitations in this case.
Why would it not be appropriate for this court to remand it back to the trial court for a hearing on that issue?
Because she did acknowledge untimely filing and there's nothing in the petition or the record to allege that, or to indicate that due process tolling would be appropriate, or that a hearing is necessary on that issue. I know the petitioner cites to several cases in her brief where this court has remanded for a hearing, but as I point out in my reply brief, in every single one of those cases, either the defendant alleges facts within her petition which would suggest due process tolling, or there are facts within the record to suggest due process tolling. Most of the time, the facts within the record are some sort of indication or a factual question regarding when the petitioner gave the petition to the prison mailroom. And the record indicates it may have been timely given to the prison mailroom, but not timely filed. Here, the petitioner freely admits in her petition she did not timely give the petition to the prison mailroom for filing, and it was given to the mailroom more than 1 year after this court's opinion. But even if this court were inclined to remand the case to give her a chance to allege due process tolling facts, that does not require the post-conviction court to hold a hearing, as the petitioner suggests in her brief. Instead, as this court reiterated in Lackey, if this court were to remand the case, the petitioner would still be required in an amended petition to allege facts to suggest due process tolling. And at that point, the post-conviction court could review the amended petition and determine whether a hearing was necessary. Here we submit that that would be the appropriate remedy if this court were inclined to remand. It is not remand with instructions for a hearing, but it's instead remand to give her the chance to allege facts that may suggest due process tolling. Based on this record, there's nothing here to indicate that those facts exist. Again, she does not indicate that she indicates that she gave the petition to the prison mailing room untimely. She raises ineffective assistance of counsel claim, which is not a grounds for relief that arose after the statute of limitations period ran. She does not allege that she was mentally incompetent, and she does not allege, or there's no indication that she was actively misled by attorney misconduct. So therefore, there are no facts within this record to indicate that due process tolling is appropriate. We submit that the petition should have been dismissed as untimely filed.
Thank you.
I'm sorry, Your Honor.
I don't have a question.
Okay. So unless there are further questions about the timeliness, alternatively, the post-conviction court improperly found that counsel was ineffective in this case. In short, the post-conviction court improperly second-guessed counsel's strategic decision not to re-interview or call ABW as a witness in this case. Counsel was aware that ABW had recanted her allegations in the past. There is some dispute as to whether he knew or not at the time ABW contacted him from Kentucky, whether she wanted to recant her allegations. His testimony was that she called him to discuss, quote, what happened. And then when he got there, she maintained that all of the allegations she made to the police were true. However, Mr. Williams testified that he knew ABW had recanted to her guardian ad litem, Peter Gray Ridley, and he also knew that she had recanted several times in the past and that her testimony, quote, changed almost daily. Because he knew that ABW had recanted many times in the past and then had reinforced her allegations as well, he learned the week of trial that she wanted to testify on her mother's behalf. But even though that was yet another recantation, he made a strategic decision not to re-interview her and not to call her as a witness at trial, because he did not know, even if he did re-interview her, he had no idea what she would have said on the stand. He did not trust her testimony, and instead he made a strategic decision to rely solely on MW's testimony, because MW's testimony had remained, or his allegations and recantations had remained consistent throughout the preparation for the case. Failure to re-interview ABW did not amount to a failure to investigate her claims, because he knew that she had recanted in the past, and he did not trust whether that recantation would stick this time, or if he did re-interview her and she recanted in the interview, he did not trust that her testimony would be the same thing that she told him during that interview. The court cannot, with 2020 hindsight, second guess that reasonable strategic decision made on the eve of trial, which is what the post-conviction court did in this case. Also, the post-conviction court ignored strong impeachment evidence that would have been used against ABW had she been called to testify at trial. Instead, this entirety of the post-conviction court's prejudice analysis was that ABW's testimony would have corroborated MW's testimony, that was, or his unimpeached version of his testimony, and it could have attacked the victim's credibility. However, the court's order does not engage at all with the fact that ABW had also been charged as a victim, and the charges against the petitioner involving ABW as a victim had been severed from trial. If she testified at trial, that would open the door for the state to introduce evidence about these allegations and charges against the petitioner regarding ABW. ABW gave multiple written and video and audio recorded statements to police alleging sexual abuse at the petitioner's hands. Additionally, excuse me. She gave multiple interviews, and she had told counsel before and had told the police before the interview in Kentucky that everything she had told police up until that point was true. Finally, she also had detailed to her therapist many instances of sexual abuse. And as demonstrated in the trial of this case, the state was able to successfully use those same therapist records to impeach MW and would have done the same to impeach ABW. The post-conviction court did not consider any of the effect of such impeachment evidence. And we submit that failure to consider that is not the appropriate prejudice analysis for Strickland. The standard is not whether ABW's testimony may have changed the outcome of trial. Instead, it is whether the testimony would have changed the outcome of trial. Here, the record does not show that had ABW testified consistently with how she did at the post-conviction hearing, that it would have changed the outcome of trial. And we submit that the court improperly found that counsel was ineffective. Unless there are any questions, I will reserve my remaining time for the moment.
Thank you, counsel. Mr. Taylor, now we're ready for you, I think.
Thank you, Judge. Thank you all for having us this afternoon. My name is John Taylor. I am court-appointed counsel for the appellee, in this case, Ms. Angela Montgomery. I would first submit to the court that this is a case of first impression. I have identified no case with this procedural history and with this issue being presented to the court. And what I mean by that is the post-conviction court finding that the petition was timely, that the statute of limitations was not raised by the state at the PCR level. And because of that, because it was not an issue in dispute, there was no evidence presented at the PCR hearing about the statute of limitations, nor about the tolling of the statute of limitations. When the PCR petition was granted, or excuse me, was heard at the hearing, the petition was granted on the merits. 6 felonies and a 40-year sentence was vacated. Since then, the defendant was released on bond, awaiting new trial. And only then, when the state appealed the granting of the PCR petition, for the first time, the state raised the issue of the statute of limitations and now seeks a summary dismissal of the PCR petition. I would submit to the court that this issue is a novel issue. Now, the state's position, according to its brief or multiple briefs, is that when it was not raised at the PCR level, and because of that, no evidence was presented on that issue, now because no evidence was presented on that issue, the petition must be summarily dismissed. And I would submit that that is, as the case law suggests, not only entirely unjust, but it deprives the appellee of due process on that issue. Now, I have argued in my brief that particularly because this is a case of first impression, I would submit to the court that because the PCR petition was granted upon the merits, that failure to raise the statute of limitations issue at the PCR level should operate as a waiver. But I do understand the case law that has been submitted by the state on that issue. And in the alternative, if this court is to find that it is not a waiver issue and that it is jurisdictional, the case law is abundantly clear, as Your Honor has pointed out. If the statute of limitations is an issue, first of all, that is a determination to be made by the trial court level, or the PCR level, which has not yet occurred in this case. And it should do so as a result of an evidentiary hearing upon the issue. And summary dismissal is not appropriate in that instance. Now, the case law that has been cited by both parties in this case raises a number of different factual scenarios under which the statute of limitations may have been missed. Rule 11 applications, misrepresentation of counsel, jail, mailroom confusion, mental incompetence, but all of them have resulted in a required hearing at the trial court level in order to determine either the strict application of the statute of limitations or the due process tolling, depending on those circumstances. And at this point, the appellee has not been provided that opportunity. And I would submit to the court that if the issue is not waived, then due process would require that the appellee have that opportunity. Now, the state relies upon 3 cases to support its contention that summary dismissal is appropriate, which I would submit to the court are grossly distinguishable from the case that we have at bar today. The state relies upon a Saines case, a McCroby case, and a LaForce case to suggest that summary dismissal at this level before this court is appropriate. And those cases are significantly distinguishable. First of all, the Saines case, the PCR petition was filed 6.5 years post-conviction, multiple years beyond the statute of limitations, and that was based upon supposed later arising grounds. The McCroby case was filed 18.5 years post-conviction, literally decades beyond what the statute of limitations would have been. And similarly, the LaForce case was filed 19.5 years, so almost 2 decades beyond what the statute of limitations is. And in all 3 of those cases, this court found that, yes, the statute of limitations was missed, but that was based upon a determination that was made at the trial court level on that issue. Now, one case that's actually been relied upon by both parties is the Lackey case. And I would submit to the court that although this is a case of first impression, given the procedural history in this case, unlike any other case, at least that I have found, that this case is most similar to the Lackey case, which addresses a similar procedural history as this one. In Lackey, the statute of limitations was not raised at the trial court level. It was, however, raised for the first time on appeal to this court, which is exactly the procedural history that we have here today. And what's important about the Lackey case as well is that no matter what the form was, whether it was in the petition or at a hearing, there was no evidence in any form that was presented to the trial court level on the issue of the statute of limitations. And it was presented to for the first time before this honorable court. And the recourse set forth by the Lackey court with this procedural history was specifically this: remanding the case to the trial court level, permitting the appellee, or well, appellant in that case, but the defendant, the PCR petitioner, permitting the petitioner to file an amended petition specifically addressing the issue of the statute of limitations, and then on remand, defer to the trial court as to the sufficiency of the evidence and or having an evidentiary hearing upon the issue of the statute of limitations. Now, what's important about the Lackey case is that it was not summarily dismissed before this court. Rather, it was remanded for the amended petition and for specific adjudication of the issue of statute of limitations and whether or not due process required a tolling of the strict application of the statute of limitations. Now, the remand was specifically because of due process concerns, which is exactly what we have in the case at bar. So as I have argued as to the statute of limitations issue in my brief, a summary dismissal when it has not been raised at the trial court level, as in Lackey, is not appropriate. Again, I would submit that the issue is waived, but even if the court determines that it's jurisdictional and it's not a waiver issue, due process concerns require, pursuant to Lackey, that it be remanded, that the petitioner be able to submit an amended petition on the issue of statute of limitations as well as possible tolling, because akin to some of the other cases that have been briefed, there is a Rule 11 application that is in the procedural history of this case that needs to be more fully explored by the trial court prior to the determination of whether it's to be strictly applied or if due process requires the tolling of the statute of limitations. And
Could you explain that a little better? What's the indication of a Rule 11 application in this record?
Well, in this case, in her petition, in her pro se petition, she had indicated the timing of the Rule 11 application prior to her filing or submitting to the prison authorities her petition for PCR. And as I stated before, that issue was not raised at the trial court level, and therefore no evidence to that effect was elicited because it was not an issue in dispute. So in that regard, I would submit that in the alternative to waiver, that due process absolutely requires for this to be remanded in order for that issue to be more directly presented in an amended petition, as in Lackey, as well as the potential for an evidentiary hearing on that point. Now, as to the sufficiency of the proof presented in the PCR hearing itself, I think on this analysis, it's important to note what the post-conviction court determined with respect to the trial. And I would indicate that the post-conviction court judge was Judge Royce Taylor, who was also the judge that presided over this trial. And in his ruling on the PCR petition, Judge Taylor noted that the trial came down to a credibility determination between AVW, who was the alleged victim, and MVW, who was one of the siblings of the alleged victim. And had AVW, which is the witness that was not called by trial counsel, the female sibling of these other two siblings, had she been able to testify to attack the credibility of the alleged victim along with her brother, it is wholly probable that the jury would have found in favor of the petitioner. Now, in light of that determination, the examination of the standard at this level regarding the sufficiency of the PCR petition is very important, because this court will defer to the PCR court on issues of witness credibility, the value of testimony, as well as the resolution of factual issues presented in the PCR hearing. Ultimately, what the trial court found was that this trial was about battling credibility. It was a credibility contest. Now, as I've set forth in my brief in extensive detail, we have the Strickland standard of PCR, which is deficiency of performance by trial counsel as well as a resulting prejudice. But more specific to the issue of failure to call a witness or failure to investigate an exculpatory material witness on behalf of the defense, the Black case dictates the standard by which that is shown at the PCR level. And what must be shown at the PCR level is the existence of a material witness, that the witness could have been discovered, that trial counsel failed to properly interview or investigate that witness. That resulted in a failure to call that witness to testify at the trial. And the failure to call the witness, the material witness, resulted in the denial of critical evidence being presented to the jury in support of the petitioner. And I would submit to the court that that is precisely the issue that we have in this case today. Likewise, the burden at the PCR hearing is for the petitioner to produce that material witness and elicit the testimony that was not presented to the jury in the actual trial. And I would submit to the court, as I have detailed in great detail in my brief, that that is exactly what did and did not happen in this case, as the court found in its granting of the PCR petition. This witness would have given critical testimony as to the innocence of the defendant, as well as assess and essentially assail the credibility of the alleged victim in this case. There is no doubt, and it's not in dispute, that this witness was known by trial counsel. In fact, he was told on multiple occasions that she was able and available and willing to testify at trial. And he obviously knew the value of her potential testimony. And this is laid out in great detail in my brief. But ultimately, trial counsel testified at the PCR hearing that he had great interest in another witness, a gentleman by the name of Peter Gray Whiteley. And his specific interest in that witness was because he knew that this witness that's in question, AVW, he knew that she had recanted her past allegations against her mother, which was the sole issue in this case. In fact, the reason why he filed 1 month before the trial in February of 2015, he filed a motion to continue the trial based upon Mr. Peter Gray Whiteley's unavailability for trial. And he felt like his testimony was so important, specifically because of this young lady's recanting her prior allegations. And the state, well, and I'll say this, and because of that, because the trial counsel knew of this young lady's recanting her testimony, knew the importance of that issue, strangely, however, through another witness, he decided that he did not want to re-interview this young lady because, quote, he had already decided that she would not be a witness in the trial. Now, he did interview her one time, long before the trial. It's when the child was in foster care. There were detectives that were involved in this case, watching and listening to his conversation with this witness. And most importantly on that issue, he knew that she knew that the detectives were watching and listening. Now, during trial prep, which trial counsel admitted was multiple days long, he was aware that this witness was out of foster care. She had reached the age of majority. She was outside of the view of the detectives. She had recanted her testimony, which he obviously knew occurred at least a month before, because that's why he tried to get the trial continued based upon the unavailability of another witness, which was specifically based upon her recanting. And he knew that she was able and willing to testify and was there locally, but he chose not to interview her, and he had already made the decision that she was not to be part of the trial. Now, the state contends that, quote, her position changed almost daily, but that can't be true because trial counsel admitted that he only had one conversation with her, and that was when she was in foster care in Kentucky, when she was in view and sight and within earshot of the detectives that were involved in this case. So that assertion cannot be true based upon our record. Second of all, the state contends that trial counsel only learned of her recantation, quote, the week of trial and didn't have time to prepare her testimony. That also cannot be true based upon our record because he had a specific interest in the other witness, Mr. Peter Gray Whiteley, specifically because she had already recanted and at least 1 month prior to trial tried to get the trial continued based upon this gentleman's unavailability. But the premise of his interest in that other witness was the fact that she had recanted. So obviously he knew of her recanting at least a month prior to trial, and certainly he knew it prior to the week of trial because he admitted to the same in the PCR hearing. Now, the state raises another interesting issue that, well, she would have been impeached similarly with some previous counseling records. Well, I would like to point out, as I did in my brief, that specific issue was directly addressed in the PCR hearing where this material witness, the female sibling, she gave specific testimony in the PCR hearing as to how she would have handled that. That she would have gone into great detail about being coerced by her father and stepmother, that she was terrified of her father, that he had made threats to her to make up these allegations against her mother on fear of him removing their disabled brother from the family, and that this material witness would not be able to see her brother anymore if she didn't make up these lies about her mother. And specifically related to the counseling records, which the other witness had been impeached upon, she would have given testimony as to how she had been coached by her father to make specific statements in these counseling sessions. So simply put, she would have been able to provide the supportive testimony to the petitioner at trial, and she was not given the opportunity to do so. Now, again, the most important issue as it relates to whether or not this was deficient performance and whether that prejudiced the defendant goes back to the trial court's analysis. This was obviously a case that hinged upon the credibility of two witnesses, the alleged victim and one sibling. And the trial court and the PCR court specifically stated that the jury should have been able to hear from the third sibling in order to assess the credibility of these witnesses and to comment specifically on the allegations in the indictment, which she was not permitted to do. Now, as to the Black standard, we have shown, and we did show at the PCR level, that there was a material witness the material witness was known by trial counsel. The material witness was not interviewed a second time, was not presented to the trial, and ultimately that witness was presented at the PCR hearing, and the favorable testimony that was not given at trial to the jury was presented in the PCR. It's respectfully submitted that both the Strickland standard and the Black standard have been met to support the PCR's finding that this petition was valid upon the merits, that vacating the judgment was appropriate, and that is the correct result in this case. And so it's our position that not only the granting of the PCR petition was supported by the evidence, but also the statute of limitations issue, one should be a waiver, but if not, due process requires that it should be remanded to the trial court for an amended petition and for further adjudication of that issue. And that would be our position in the case. Thank you. Thank you all.
Thank you, Mr. Taylor. General Orr, do you have any rebuttal?
Yes, briefly, Your Honor. First, while we agree that this is a unique procedural history that we do not see very often, the statute of limitations and due process tolling argument is not an issue of first impression before this court. Indeed, this court explicitly held in 2018, quote, "If we conclude that a post-conviction court did not have jurisdiction to consider a petition for post-conviction relief because it was untimely and due process did not require tolling of the statute of limitations, this court must dismiss the appeal even if the state did not raise the statute of limitations and the post-conviction court treated the petition as timely." That is from Ruby Ruiz versus State. Also, that is reliant on the fact in both the statute and in State versus Nix, the Tennessee Supreme Court, it is firmly placed on the petitioner's burden. The petitioner, it is incumbent upon the petitioner to raise facts within the petition that would show either timely filing or due process tolling. And here, the petitioner wholly failed to do that. Next, as to a due process hearing requirement, even Lackey in this case does not require a hearing or remand for this case. As I noted before, it was incumbent upon the petitioner to allege facts within her petition to show due process tolling, and she failed to do that. But even if this case were remanded, it would not require, Lackey would not require a hearing for due process tolling. Instead, it would still be incumbent upon the petitioner to raise facts within her amended petition, if that is allowed, to show due process tolling. And if she were under Lackey, if she fails to allege due process tolling facts, the court is not required to hold a hearing for due process tolling, which is the explicit holding in Lackey. And here again,
This is a little bit unique in that we rarely see a petitioner admit that a petition's untimely, but make no arguments as to why it should be told.
yes, Your Honor, it is quite a rare occurrence. But again, that is what's spoken to in Nix is either the petitioner has to allege facts to show timeliness, or she has to allege facts to show due process tolling within the petition. And here she failed to do that. And again, a lot of these prison mailroom cases we see, there is some sort of question as to whether it was timely delivered to the prison mailroom, which was the case in Lackey. It was a question of fact of whether it was timely delivered to the mailroom. Here she freely admits that it was not. And we submit that under the statute and under State versus Nix, the jurisdictional requirement was not met in this case, and therefore the post-conviction court lacked jurisdiction to consider her claims. That jurisdictional argument does not turn on whether that petition was 18 years late or 3 months late or 3 weeks late. It is jurisdictional, and failure to satisfy the jurisdictional requirements deprives the court of jurisdiction. I will note in the petition, She does not allege that she had tried to file a Rule 11 application. Instead, what she alleges is it is timely because there is a 60-day period from the date of the application to the date a Rule 11 application would be, excuse me, the date of opinion to the date that the application would be due. She does not claim, as far as my memory, that she tried to file a Rule 11 application. I will defer to the record to that. But I do know I have pulled this court's procedural history from her direct appeal, and no Rule 11 application was filed. Finally, just briefly turning to the alternative merits arguments, while yes, this court defers to factual findings and credibility findings regarding the witnesses at the post-conviction hearing, we submit that the record preponderates against some of the post-conviction court's factual findings, which is detailed in our brief. And further, as it relates to the prejudice analysis, application of Strickland and whether the petitioner was prejudiced or not by counsel's performance is a question of law, which this court reviews de novo on appeal. Finally, regarding Peter Gray Whitley's allegations of recantation, I submit it may be unartfully drafted within my brief, but yes, I believe both parties agree that counsel at some point in the preparation for trial knew that ABW had recounted her testimony. She testified to that as much. He interviewed her in Kentucky, and then he also knew from Peter Gray Whitley that she had recanted before. His strategic decision was based on the fact that I knew she had recanted in the past. I did not know what she was going to tell me that day. And I did not trust that what she could have told me in a re-interview would have been the same as what she would have said on the stand. That, we submit, is the strategic decision that could not be second-guessed in this case. Unless there are any further questions by this court, we ask that you reverse the judgment of the post-conviction court.
Thank you, counsel. Very good arguments, and thank you for being here virtually. Hopefully we won't be doing this too much longer. That concludes this case. Court will be in recess.
This
Thank you.
court is now in recess.